Number 47, Carlson versus AIG. Good afternoon, counsel.
Good afternoon, Your Honors. May it please the Court, Ed Markarian for the plaintiff, and we request 2 minutes for rebuttal.
Yes, sir.
Thank you, Your Honors. Your Honors, as the Court knows, there are 3 issues in this case: the hired auto insurance coverage question, the permission question, and the statutory issued or delivered question under Section 3420.
Well, if we decide the hired auto issue against the position you're advocating, doesn't that really dispose of the other issues?
Your Honor, that question was asked last time.
By me.
I think I said it was moot. I think the actual doctrine is judicial restraint, that your court should decide only the issues necessary. So we ask that you find in our favor on all issues, Your Honor.
Can I ask you, because there's been a lot about the missing cost for hire schedule. Can you point to me where in the record you raised its absence before the trial court?
At the motion court, Your Honor, the argument was the generic argument that the insurance company had the burden of conclusively proving that their documentary evidence showed their defense conclusively. That was the argument.
How is that preserved for purposes of our review?
Because the burden is the same now, Your Honor. They have to explain on this record how they have conclusively proven that there is no coverage.
But haven't we said that an appropriate, that the court has to be alerted to the issue so that it can properly address and review it in order to preserve it for our review? I realize that the rules are different for what the appellate division can review, but...
Correct, Your Honor. 2 points on that. Number one is that the standard for preservation is that had the issue been raised more specifically than it was, they could have done something about it. And they have never contended that they've been able to produce a schedule. We were here last time. They did not say that. They were specifically asked a direct question, can you produce a schedule? They said they did not answer the question. They did not say they could produce it. And so
And what would the schedule have shown in your view?
it would have shown what the underwriting evidence shows, Your Honor, which is overwhelming.
But if the underwriting evidence is there was liability for these vehicles, there was potential liability for these vehicles, right? I mean, you proved it in the first trial, but
Correct.
you lost the verdict on a vicarious liability theory, right?
Correct, Your Honor.
So how is that inconsistent? I mean, if they had been using this vehicle with the permission of DHL, you would have won.
Correct, Your Honor, and the insurance amicus makes this point, and it's technical, but it's crucial, and you have to understand the 9 symbols of coverage. Their insurance amicus is saying that DHL did have coverage. It wanted coverage under symbol 1, which is any auto coverage. And they say that that means they were literally covered for any auto in the universe, and that's a misstatement of how insurance coverage works for symbols 1 through 9. As the plaintiff's expert explained, but also in the Donegal case and the Bambar case that we have cited in our reply to the amicus explains, you don't have coverage for any auto under symbol 1. You have coverage for any covered auto. So for DHL to have coverage for itself, as your question says they would want, and as the insurance amicus says, if they're going to have coverage for themselves under symbol 1, there has to be coverage under symbols 2 through 9. You don't have coverage for every auto in the universe. Symbols 2 through 6 are the autos that DHL owns. Of course it has coverage for those. It can have coverage for an auto it doesn't own under symbol 7 if it specifically lists that vehicle in the policy. And it can have coverage for non-employee or for employee vehicles under symbol 9. But if DHL wants coverage for the contractor vehicles, the only symbol that can provide that coverage for DHL under symbol 1 is hired auto coverage under symbol 8. So they did want the coverage.
But can't they have coverage, which I assume they did in the first trial, for your theory of vicarious liability? Wouldn't they need coverage for that?
Yes, and they had it. And they weren't liable for that. But this is not that question. This is not a vicarious liability coverage case. This is a
I
coverage
understand,
case.
but a lot of your brief also talks about DHL's obligation to have coverage, and they have these vans, and they have these markings, but in a way, they do have coverage, because when they're using those vans for the right purposes, they're responsible, and their insurance carriers, I assume, came in and defended them in that first trial.
Yes.
That verdict got thrown out because you didn't have a vicarious liability theory on the permission issue, and it seems to me part of the struggle maybe we're having with this case is it's a somewhat unusual use of 3420. because it seems to me that statute goes to, you have an insolvent defendant, they're not really interested one way or another of bringing their insurance carrier in, you can kind of go around that and bring them in. You lost on appeal in the first trial, and now you're flipping a theory to bring in the carriers under this other statute.
not-
And I never saw that in another case, and maybe you could point to.
We're not flipping it, Your Honor. Had they specifically identified the vehicles, there would be coverage. When they place the coverage under symbol 8, which is they wanted the coverage, the only way they can have the coverage that they want is to insure the vehicles under symbol 8. Symbol 8 through symbol 1 gives the coverage to DHL, and that's why they had coverage. That's why they had counsel at the first trial. But when you get the coverage for symbol 8, you also, the policy is explicit. The coverage is for you and anyone driving the vehicle and owning the vehicle. And that's why the coverage is not just for DHL. It's for the contractors and the driver.
Now, regarding the cartage agreement itself, which is extensive, it's some 14 pages. Now, where is it in the cartage agreement that you have an expression of control of the vehicles by DHL? Where is it that we can find that?
Your Honor, there are many provisions in the agreement that show control, but I think that
Well,
it's,
control of the vehicles, we have control of the operation of MVP, and that's exhaustive. But what about control of the vehicles themselves as being utilized in their service?
I'd like to answer it two ways. Generally, Your Honors, when you ask in this business, this cartage business, when you ask someone to step into your shoes, and more than half of the vehicles, you're hiring all these fleets, and more than half of the vehicles making your deliveries are these contractor vehicles, you are controlling them. But the more important point, Your Honor, is, and the Academy of Trial Lawyers brief shows this very well, there's this whole sub-industry out there for sub-haulers. And for sub-haulers, they're insured on a cost of hire basis. And to hold, as the insurance amicus says, that we should ignore what the cost of hire schedule does, is a ruling that all these vehicles nationwide identified on a cost of hire schedule, none of them are going to have coverage, and that would be devastating, Your Honor. If they're on the schedule, they're covered.
Well, is this a question of whether the vehicles are covered or of whether 3420 applies?
Well,
Are those the same questions?
no,
I
they're
guess?
not, Your Honor.
Okay.
3420 is just whether we can sue AAIC directly in New York, and the answer to that is yes. That's an important issue of statutory consequence. May I address that quickly,
Yes,
Your Honor?
please.
Just on the AAIC 3420 issue, you have to look to see whether the statute, when it was amended in 2008, did they change the meaning of issued or delivered in D? Because now it's, well, it was issued or issued for delivery, now it's issued or delivered, which is the same language in A. When you look at the legislative history, you'll see two things. You'll see all of the amendments broaden the protections of the statute. The appellate division here allows an insurance company to eviscerate the statute simply by mailing the policy outside of New York to a non-New York address of the insured. That's not what was going on in 2008. On the other hand, you'll see a whole series of non-substantive edits, pure edits that were done in 2008. For example, the word hereof was twice replaced with of this section. The word his
That may
was...
be true, but don't we have to look at the plain language? It was changed. We have to assume that it was changed for some reason.
Right.
And there's not much said about it, so it's really not clear. But the fact of the matter is that it's not the same language as it was before.
Correct, Your Honor.
And we've never interpreted this new language.
Correct, but the
correct?
plain language of preserver was issued or issued for delivery. It's not substantively different. And when you look at what they changed,
Well, it may not be, but when, I mean, it may or may not be. And this language, is this language used elsewhere in the
yes,
country? Okay.
well, it was used elsewhere in the statute. It was used in subdivisions A, E, and F.
Well, that's-
And when they changed the statute in 2008, they changed issued or issued for delivery to issued or delivered in D, and in J, they changed issued or renewed to issued or delivered.
So if we change, if we interpret it in this particular way, it's going to affect, in the way you're proposing, it's going to affect other provisions, and we don't know what the effect on those provisions are
We
going to
do.
be.
We know that an insurance company can now defeat all of these protections of 3420, which are for injured parties and for policyholders. They can defeat them all just by mailing the policy from an office outside of New York. When you look at the legislative history, there's no reference to preserver. Preserver was decided 13 days before the statute was amended.
But we were addressing different language. If the language had been what it is today, we don't know that we would have reached the same interpretation.
I submit that when you see they tweaked subdivision J the same way, and you see all the other non-substantive edits, it was purely an editorial, non-substantive change. And to hold otherwise allows this important statute to be defeated by a mailing test, and I submit that would be bad public policy. The preserver test is correct. If an insurance company takes payment to insure somebody who's located in New York and creates risks in New York, they should be subject to the New York law. To allow an insurance company to defeat that by a mailing test, I submit would be an improper result.
Thank you,
Your
sir.
Honors.
Counsel?
Good afternoon. Chief Judge DiFiore, and may it please the Court, I'd like to begin with the questions of Judge Stein and Judge Garcia and address the issues of control and permission in the context of those questions. First, Judge Stein, you're absolutely correct. Not only was the issue of the purportedly missing schedule not raised below, but on pages 1538 to 1540 of the record, you can see where the plaintiff's counsel took the position that the policy was clear and unambiguous. With respect to your question, Judge Garcia, what would the underwriting have shown? The underwriting would have shown that, and in fact, the plaintiff's position in his response to the amicus brief takes this position at pages 5 and 6. It would have shown that the policy was intended to provide hired auto coverage. We don't dispute that. The policy provides coverage to DHL for any vehicle, any covered auto, whether it's a hired auto, a rented auto, or a DHL-owned auto. But that is not the question in this appeal. The question is whether MVP is an insured. And in order to answer that question, the court has to determine whether the MVP van was, at the time of the accident, hired by DHL and being used with DHL's permission.
Well, were the MVP vans at any point covered by the policy?
Thank you, Judge.
Isn't that what the schedule would show if we had it?
Well, Judge Wilson, according to the plaintiff's response to the amicus brief, the schedule would show fairly consistently what the columns in the schedule indicate. It would show a state-by-state breakdown of where DHL does business, a cost of hire per state, and various factor and premium calculations. The plaintiff does not take the position that the schedule would show either a list of vehicles or a list of contractors.
Number of vehicles?
The number of vehicles hired and or non-owned and owned is reflected in the underwriting files that were produced as part of the motion to dismiss, but it does not appear that those figures would be included in the schedule. Again, Judge Wilson, I think the most the schedule would show is a point that is not in dispute here, which is that the policies were meant to cover DHL's liability for hired autos.
And that, counsel, going back to an earlier point, would that cover, I mean, I assume that would cover liability related to certain vehicles like these if they had been used with your permission? So the first trial, that would be a calculated liability in your policies, right?
I think that's right, Judge Garcia. If the trial, suppose the trial had gone the other way and the appellate division had affirmed the judgment on the
Right.
verdict, DHL would have been covered for that judgment. If MVP had sought coverage at that point, MVP would have had an additional burden because MVP is not the named insured. So to establish coverage as an insured, MVP would have had to establish that the van was hired by DHL and being used with DHL's permission. Now,
There are circumstances in which DHL's permission comes into play. Is that not a fact under the cartage agreement?
I'm not
There's
sure.
one situation that I saw in the agreement, and that's where, of course, MVP seeks to use a vehicle for a competing service. And if that's done, it requires the written permission of DHL and requires that the markings be taken off. So it does contemplate permission under some circumstances. Does it not that DHL does stand in a position to give permission?
I don't think it contemplates, thank you for the question, Judge Ang. I don't think it contemplates permission to use the vehicle, but I do agree with your point that
Well, no, but it says explicitly they can't use a vehicle for that purpose without their written authorization.
Yes, and we think that those provisions that govern DHL's intellectual property or its marks reflect DHL's interest in controlling its brand. It does not reflect control over the vehicle itself. In fact, in the record on page 433, Your Honor, there is a particular provision at the very end of section 3.5.1 in which MVP agrees that it will not permit its vehicles to be used for anything other than services under the agreement. So I think taken as a whole, Judge Ang, the cartage agreement makes clear that whatever may be said, even if we adopted the plaintiff's arguments for a moment that
Under the cartage agreement, might it have been permissible for MVP to do a delivery for DHL in an unmarked vehicle with a driver in a green jumpsuit? Would that have been permissible?
and you're referring to the mark section, Judge Ang.
Well,
I
I'm
think-
referring to their doing their duty as an independent contractor. Would the cartage agreement permit them to deliver this service without a marked truck and without a uniformed driver?
on behalf of a
On
competitor.
behalf of yes.
I think I'm familiar with the provision you're referring to, Your Honor, and I think if it weren't marked with a DHL mark,
But could they do DHL's business in an unmarked vehicle with a non-uniformed driver?
I don't know that anything would have precluded that, Your Honor, but the agreement clearly contemplates that the work would be done in DHL vehicles.
Because what I'm looking
in
at is a
certain
high
uniforms.
element of control here that seems to permeate this.
Well, I think, Your Honor, I think the court should distinguish between attempts to control DHL's branding and its intellectual property and how it appears on uniforms and vehicles, and attempts to control the vehicle itself.
Well, it's even more than that. What about COD provisions, for example? It says that MVP shall collect monies for COD shipments and remit them. When you're collecting money for a service, are you not acting as an agent?
No, Judge Ang. I think you're acting in an arm's-length relationship under a contract. And I would go back to the question that you asked of my friend in his initial argument. There may be instances under the agreement where DHL attempts to have hold over its intellectual property and its brand, but when it comes to the vehicles itself, the cartage agreement makes absolutely clear that MVP has free control of the manner and means of production.
What about
including its
routing
work.
specifications? What does that mean? I know in the agreement it says that MVP shall be responsible for routing, but then it says they should follow the routing specifications of DHL. What does that mean?
Right. I think that there's clearly some interplay, Judge Ang, but the agreement does afford MVP the discretion to determine the routes. So I think looking at the agreement in a whole, there are some provisions that one side or the other may want to pick out and cite as evidence of control or lack of control. But on balance and taking the agreement as a whole, and the documentary evidence conclusively establishes that it was MVP that controlled the vehicles. But even if this court, and I wanted to pick up on a question that Judge Rivera had asked in the initial argument. Judge Rivera, you asked the question that, is it possible to assume that because DHL retains the services of MVP, if they hire MVP, aren't they implicitly hiring the vehicles, even if it's unstated? And although we disagree with that proposition, I just wanted to fully respond to your question, because I think even if this court assumes that hiring of MVP constitutes hiring of the vehicles, and that hiring of the vehicles somehow constitutes an implicit permission to use the vehicles, that permission is limited to work being performed under the cartage agreement itself. So
There's a difference there between what symbols 9 and symbols 8 say, right, in the agreement, where symbol 9 has a specific carve-out of the type you just articulated, and symbol 8 doesn't.
Well, I think that's true, Judge Wilson, but the fact that, I don't think this is a case about symbols, but if it were, the fact that symbol 1, which broadly covers any auto, I think that's sufficient to subsume all of the other symbols, and it reflects the party's intent to cover DHL's liability for any auto, including hired autos. That's not an issue that we dispute. The question is whether MVP is an insured, and that requires a different analysis. The question is whether the vehicle was hired and used with permission. And I think on that question of permission, we have something here that is not typically found in other cases. We have a determination.
I want to make sure I understand you. Then it sounds to me like you're not disputing that it was hired. It's really the permission part.
No, we do dispute that it was hired, and we do dispute permission. What we're saying is that we don't dispute, we agree that the policy was intended to provide hired auto coverage to DHL. There's no question about that. And that's what the underwriting information reflects. It reflects that DHL's liability for any auto, including a hired auto, is covered.
So you're still disputing that the MVP vehicles were hired autos under the contract?
Absolutely correct. That's a separate analysis. And just to conclude, the Fourth Department's decision in which it found that the driver of the vehicle was on a personal errand and that his employment did not create the necessity for the travel is and I see that my time has expired.
Please
Chief Judge,
continue.
may I conclude? That is a critical determination for this appeal, because essentially it reflects that it is undisputed on the record that the driver was operating outside the scope of the cartage agreement, outside the scope of his employment at the time of the accident. Given that, even if the plaintiff could establish that the vehicle was hired, and even if the plaintiff could establish that some permission existed at some point to use the vehicle, at the time of the accident, there was not and could not have been permission. So even if the plaintiff's arguments were accepted at this stage of the appeal, it's our view that the decision should nonetheless be affirmed.
Thank you, counsel.
Thank you
Counsel?
very much.
May it please the court, my name is Paul Kovner, and I represent American Alternative Insurance Company. I think the plaintiff is asking the court, in essence, to apply the test which you enunciated in the Preserver case, but that language was changed, as your honors have noted, by the amendment to 3420 in 2008.
That's actually not the argument you made in the appellate division, right? In the appellate division, you didn't make that argument, correct?
What we said in the appellate division was the court should construe the language in the amended statute which says issued or delivered, but we also made the argument that even if the court were to apply the issued for delivery standard in the Preserver case, the action should still be dismissed because the policy was not issued for delivery in New York. So I don't think the issue has been preserved. The public policy arguments that they're making about the potential impact on injured victims in New York. They didn't raise the issue at the motion level, and they didn't raise the issue in the appellate division. So I think the argument relating to public policy has not been preserved in this court. And I think what this court needs to do, should it reach the issue, and obviously, as His Honor pointed out, if you decide in favor of the defendants on the hired auto issues, it need not reach the interpretation of the amended statute. But if you do reach the interpretation of the amended statute, I think the Fourth Department got it right. Issued or delivered requires that the policy either be issued in New York or delivered in New York.
That's literal. Is there anything that suggests that this should be what it means, something so literal to restrain or narrow the protection and the coverages that obviously the legislature seeks to expand?
Well, I think the legislature did expand the coverage here when it changed the statute, but to answer your question directly, I think in the Preserver case, this court did construe the word issued in the same way that the Fourth Department did. Where was it underwritten? Here, the policy was issued in New Jersey because that's where American Alternative was located. But as I said, I believe
It-
yeah, I'm sorry.
3420 is in derogation of the common law, is it not?
yes.
So, so does that require us to construe this language narrowly?
Yes, I think it does. And as I said, because the plaintiff has raised questions about whether the amendments increase protections or decrease protections for injured motorists, I think there's a reasonable interpretation which would suggest that it did increase the protection, because under the issued or delivered language, the plaintiff could bring a direct action with respect to a policy which was issued in New York but delivered to an insured located in another state. So with that in mind, I think the amendment did increase the coverage available to injured plaintiffs.
Thank you, counsel.
Thank you.
Counsel?
Good afternoon. May it please the court, my name is Patrick Lawless, and I represent the respondent DHL. The sole claim against DHL in this case is a conspiracy claim that was properly dismissed by the lower court and affirmed by the Fourth Department. New York State doesn't recognize a civil cause of action for conspiracy. There has to be an underlying tort, which in this case would be misrepresentation or fraud, which is subject to a heightened pleading requirement. The conclusory and vague allegations of the complaint don't meet this requirement, especially in light of the prior determinations of the Fourth Department. Unless the panel has any further questions for me, I'll rest on my brief.
Thank you, counsel. Counsel?
Could you just address that last point? Are you contesting that?
We do think that this is such a distorted case where DHL is fronting the insurance that we have concerns that they are in lockstep with the insurance company. So we would ask for discovery on those points. That's where those issues come from. On the other issues, Your Honors, there was a question about vicarious liability, and I would ask that the court not be distracted by the vicarious liability holding at the first trial, because this is an insurance coverage case, and the policy says who is uninsured, you meaning DHL. We're not trying to enforce a judgment against DHL. It says you, DHL, and anyone else while using with your permission the cover auto you own or hire. So it's not about vicarious liability of DHL. It's the driver who's covered under the express language of the policy, and also his employer, the owner of the vehicle, is expressly covered. This is not a vicarious liability. It's strictly coverage, and that vehicle is covered under the terms of the policy.
Counsel argues that as to permission, that the timing of the crash is
Yes.
what was key. Would you
Right.
address that?
Yes, thank you, Your Honor. This comes into the symbol 8 versus symbol 9 point, and we've now supplied the court with the Hanneman case that makes the exact argument we've been making. What they're asking the court to do is say that non-business use equals no permission, and that's not what the policy says. The policy says in 8 versus 9, and 9, when it says non-business use means no coverage, it's explicit. It doesn't say that in symbol 8, and so the Hanneman case makes the same analysis we do. You know how to take away the coverage for non-business use, and they don't do it in symbol 8 like they do in symbol 9. And I would ask the court, again, this is a distorted case because DHL is the policyholder. They are united with the insurance companies. I would ask the court to consider the garden variety hired auto case, because the holding here will apply there. I have a business. I have one truck. It broke down this morning. I go to Ryder. I rent the truck for the day. I tell my driver, don't go to Burger King when you make the delivery, and he goes to Burger King and he gets in the accident. I need the hired auto coverage to be just as good as my owned auto coverage. That's the principle of hired auto coverage. That's why the policy equates hired auto with owned and hired in the same sentence of the policy, and why under symbol 8 it does not withdraw the coverage for a non-business use. You need the hired auto coverage to be just as good.
In some other jurisdictions, of course, you have a requirement that the vehicle be specifically contracted for and that there be exclusive control. Now, do you think the court should set up a nebulous guideline over here as to what is hired and what is not? When other jurisdictions have specifically outlined what they believe the requirements are?
Your Honor, on a 3211 motion, we need to see what the insurance company thought. That's the key on hired auto coverage. We need to see if the insurance company thought it was insured as hired. And we will know that, we do know it from the underwriting, we will know it some more from the cost of hire schedule. So we don't need this test. In the Dairy Lee case from this court, the first thing this court did was not get into the single tank, single truck rule and the control. The first thing this court did was look to see if there was an exclusion. It looked to the policy. And that's what the court needs to do here. What does the policy say? If the insurance company wants to insure this vehicle, and now the amicus admits DHL wanted this insurance, the only way to get it here was under symbol 8 for hired auto coverage. And that should control the analysis on a 3211 motion. What did the insurance company say?
Thank you, counsel.